Okay, we're on live stream on YouTube. So, Ms. Pais, if you're ready to start?
Yes, sir, I am.
All right, let me call the case for the record. This is cause number 20-3213. This is in the estate of Gilbert C. Gonzalez. Judge Homer Garza presiding by assignment for Duval, the Constitutional County Court of Duval County. I guess let me have announcements from both attorneys.
Diamond De Leon for petitioner Aaron Trigo, who's present, Your Honor.
And Joshua Spencer on behalf of Yvonne Gonzalez, who is also a counter applicant for the estate of Gilberto Gonzalez. Your Honor, my client is not present and we are not ready.
I do not.
I'm trying to verify notice for today's hearing, Your Honor, and I can't seem to confirm that information.
Are you kidding me?
Let me share the address and the emails that I used to see if okay, the order set in a hearing date. I sent you directly a copy. Joshua C. Spencer, attorney at law, joshua@joespencerlaw.com. Is that your email?
Joshua@joespencerlaw.com. Yes, Judge. When was that email sent?
When?
Yes, sir.
August 18th. On August 18th, I also ordered the clerk to give notice to all counsel of record of this setting on the same date. So I sent you a direct email and I ordered the clerk give you notice directly. If you check, maybe check your email first.
That's what I'm doing, Your Honor. Do you have a? Let me check again, Judge. I'm looking for it.
It would be August 18th.
Yes, sir. Joshua is JOSHUA at JOESPENCERLAW.com.
Yes. Joshua, JOSHUA at joespencerlaw.com. Ms. Pais, if you can hear me.
Yes, sir.
Could you make an inquiry? Hold on, Mr. Spencer. Could you make an inquiry of the clerk's office if they sent Mr. Spencer the notice of hearing?
Check.
While she's looking, Mr. Spencer, you were going to say something?
Judge, I did receive it, and I should have had it.
No,
I should have had it.
I'm sorry, who's speaking in the background, please? If you have something to say, you have to be under oath, so I'll ask you to please refrain from making any comment.
I'm sorry, sir.
All right, go ahead.
Okay, Judge. Well, I did receive it. I do see it now, and it should have been documented. I do see Mr. De Leon, when he responded, he received it as well. I typically forward everything that I get to my staff and to my office, and that usually gets calendared. So I don't know what to tell you, Judge. I just don't have it. I don't have it docketed right now, and unfortunately, Judge, I'm not ready to proceed. I need my client to be available to testify, and just to verify. Today's setting is a setting on pending contested matters.
Well,
Okay.
that's a big question on my mind as to exactly what matters are pending. And it depends on whether there's a will or not.
Right.
If there's not a will, I'm not sure what jury issue would require the appointment of a statutory probate judge. So,
Judge, maybe I could help.
yes, sir. Go ahead, Mr.
Thank you.
Your
We're
Honor,
not
we
having the hearing yet, Mr. Spencer. I'll consider your motion, your oral motion for continuance in a minute. I just want to make sure that we have somewhere to go with this thing.
Yes, sir.
yes, Your Honor, thank you. Basically, Your Honor, we had a petition to probate will, but we did, we being petitioners, Aaron Trigo, represented by myself, we were informed there was a will, so we filed a petition to produce will as well. Came to find out there is no unsigned, there's an unsigned, unexecuted will. So I guess there could be a potential issue of whether there is a valid will or not. And then more importantly, Judge, the property of the estate is at issue because we had filed an injunction against a respondent who has property belonging outside of the estate and to people other than the decedent. And the temporary restraining order and injunction was signed by Judge Sines last year, but the property was never turned over. So we filed a show cause hearing to ask for a show cause setting to ask why the property, namely cattle, hasn't been returned. And then that's when the respondents filed a motion to appoint you, Your Honor.
Okay, I remember a deed being asserted as having been executed. Is that what conveyed real property?
Correct, Your Honor. I don't believe
What
that's
about cattle? How did that get conveyed?
basically, Judge, the respondent who is not present, she broke into this property, cut the locks, rounded up the cattle and some horses, took them off site and has not returned them. And it's been over a year. Two of those cows, Judge, at least one of them was pregnant at the time, so I'm sure she's dropped by now.
Okay, because those cattle, how were they conveyed to your client?
So, Your Honor, they were sold, and we've got witnesses and receipts.
They were what?
They were sold, Your Honor, paid for by my client. They're not.
Oh, so you're saying they're hers individually.
Yes, my clients, Your Honor, Aaron Trigos, we're saying those are his.
Your client is related to the deceased in house, or?
He's the son, Your Honor.
Okay, so you have cattle that belongs, you assert to your client that never was a state asset.
Correct, Your Honor.
Okay,
Oh, we didn't have the cows.
Mr. Spencer, go ahead, sir. Tell me what
So
do you think, what would be the subject of a jury trial in this case?
The existence of a will. So like Mr. De Leon said, we produced an unsigned will because that's all that my client had in their possession. There was reason to believe that the signed will was on the decedent's property. Now, it's my understanding that the decedent, or that Mr. De Leon's client got onto the property upon Mr. Gonzalez's death. That he was not on the property before. And the locks that were broken were locks that they put on when they never had access to that property to begin with, is my understanding. And there is a fact issue as to whether or not Mr. De Leon's client is an heir. There's reason to believe that he's not even an heir. He's not a biological son.
Okay, well, if the heirship's gonna be contested, that would be a jury trial, certainly.
So
So
there-
the will, so Mr. De Leon, you have a copy of the unsigned will?
Your Honor, Mr. Spencer has provided the blank will to us.
Okay, are you gonna proffer it for admission, or what are you gonna do with that?
Well, Judge, at this point, our contention is there is no valid will. The only reason we petitioned this court to probate the will was because the respondent, who is my client's sister, had informed him that she had the will, Judge, but she would not turn it over to us.
Mr. Spencer, if he's not gonna offer the will for probate, are you gonna offer the will for probate?
yes, Judge, so I need to prove up the will.
Okay,
So,
well,
yes,
one of the things I asked in my letter to you was that you give me copies of all your live pleadings. Have you filed that?
Judge, I don't know, Your Honor. I don't know if I'm not sure whether or not we have filed the blank will. And that's something that I need to review from the court's file, because what's in my file and what's in the court's file is not complete, which is why I'm unprepared to proceed, because I'm not sure what is filed and what's pending.
What are the terms of the will that you're gonna proffer, sir?
Well, Your Honor, who are the beneficiaries? Who's entitled to the estate?
No, I'm not asking you. So who do you assert are named as beneficiaries in the will?
My client and Gilbert Gonzalez Jr.
That would be Ivan Gonzalez and Gilbert Gonzalez Jr.
And the executor of the will is Cynthia Gonzalez Renteria, who is the decedent's sister.
Okay, so so if I understand, then are you contest? I could be confusing cases. Is my memory correct that this TRO relief that was granted was based on a presentation of an executed deed leaving the property to one of Mr. De Leon's clients?
Well,
Correct,
if
Judge.
you're asking- yeah, well, if you're asking me, Judge, that's right. That there was a deed that was executed just before his death, and we're contesting that was unduly influenced during a time where the decedent at the time was not did not have the mental capacity to execute such an instrument.
Okay, have you filed a lawsuit to contest the validity of the deed?
The probate court is without the proper forum to decide whether or not, first of all, only in the probate court we thought that matter would be relevant.
Okay, so you agree that, do you intend to file that in this case here?
Yes, Your Honor.
But you haven't.
I don't believe so, Judge.
Judge, from my records, if I may, there's a general denial on file, and that's all in this cause number.
Okay, so Mr. Spencer, you're telling me that you're gonna file a pleading proffering an unsigned will. Then you're gonna file a pleading questioning the capacity of Mr. Gonzalez to have executed a deed. And Mr. De Leon, you're gonna file, well, no one has filed,
An airship
I guess it
determination.
waits, yeah, I guess the airship has to wait until the will contest.
And Judge,
Oh, well, there's plenty of jury trial issues, but there's no application to determine airship. There's no application on your part, Mr. Spencer, to probate what your will. Mr. De Leon has indicated he's not going to proffer the copy. I've lost somebody here. Mr. Spencer,
I'm here, Judge. Mr. De Leon
you
just got
shifted
cut off.
blocks on me. Oh yeah, Mr. De Leon, I've lost you. Mr. De Leon?
He's not here yet, Judge. We gotta probably try to log back on here in a minute.
Good waiting.
Okay, Mr. Leon, we lost you, but
I apologize, Judge. I got booted off I didn't hear anything probably for the last minute or so, Judge.
okay, I don't even remember what we discussed in the last minute or so.
The
There's
last thing
plenty
I
of-
heard,
Rather than, my impression was that there really probably wasn't any jury issue. If there was no will and an airship, unless it was going to be contested with something that would revert back to the county judge. But in light of your assertion, Mr. De Leon, that you would contest, or I'm sorry, Mr. Spencer would contest the airship. I'm sorry, I may be confusing you all. One of you also not willing to accept one of the asserted children as being an heir. Any one of those three is a legitimate jury trial issue. We don't have any pleadings. Something needs to happen quick on pleadings.
Yes, Judge, and just to a little background, Judge, I don't remember if Mr. De Leon filed first or if I filed first, but I filed in another county. And then and Mr. De Leon, correct me if I'm wrong. I think there was two probate courts. We're dealing with the same decedent, and then we ended up agreeing to go to Duval County. So there's some pleadings in the other county that I need to pull up that what I filed. So, but those pleadings are obviously not here in this cause number.
Where did you file the other pleading, Mr. Spencer?
I believe it was Alice, Judge, and I filed a plea to the jurisdiction, and that case was dismissed, Your Honor.
Okay, so it's been
Resolved.
It's been disposed.
Yes, sir.
Judge, I would just want to point out that whenever I filed the show cause last year in August of 2020, the respondent did not appear at that hearing either.
Okay.
Yeah,
Mr. Spencer, how much time do you need to file your pleadings, to get your pleadings in order?
Judge, I'd ask for at least 30 days, Judge.
Response, Mr. De Leon?
Judge, we object to any continuance from today. These cattle have been held by respondent for over a year. They were pregnant. We've shown the temporary administrator who was in on this case, all of the receipts and everything, and there hasn't been a shred of evidence stating otherwise, Judge. These cattle have been born, so there's more than what had started, still being held outside of my client. There's no remedy for him. They're getting older, they're growing up. There's still a lot, Judge. And the horses are out there too. All this livestock, Judge, it's just been sitting there for a year. We can't get them back.
Have you sued them for, I don't know, what would that be, conversion or?
It would be theft, Judge. We wanted this court order That's why we filed the show cause, because it was actually granted in August, on August, I believe, 7th of 2020 last year, Judge. The judge ordered that the respondent turn this livestock over, but it just had never happened. So we gave him 30 days, and then we filed for the show cause, Judge, and then here we are a year and 30 days later.
Okay, I received from you some of your pleadings. I received from you a proposed order that was not signed by the judge. Although I had the impression that that the judge had signed something. I don't have it in front of me. And so I got the impression that the TRO was granted, temporary injunction was granted, and
Correct, Your Honor.
I don't know that I have a recollection about the cattle or the horses.
They're specifically referenced in the injunction, Your Honor.
And they, I guess, Mr. De Leon, would you favor me a copy of the order signed by the judge when we finish here? But by the way, what does it say about with regard to the cattle and the horses?
Judge, if you can allow the share screen function, I could share with everybody the signed copy and we can go through it. It specifically references the horses and cattle, as well as the property in question in the deed. There were findings of facts that it was properly executed and recorded, and the property is owned by Larissa Trijo in fee simple, who's also present here today.
And so what would be your next remedy? So what does the judge order them to do?
The judge,
I can share the thing, but I need a copy so that I can review it. But in the meantime,
absolutely.
I'm curious. I want to get everybody kind of on marching orders on pleadings. I mean, if I don't have any recollection about the show cause order that would have been the show cause.
The show cause was not signed.
Okay, so it never was set for contempt for failure to, so
It
what?
was.
Okay, so I never was aware that I had, although I set all pending matters in case I missed something. So you're saying that by that order, you're asserting that your show cause, that was never set for hearing.
It was set, we showed up, respondent did not show up, Your Honor, and then 3 days later, they filed the removal to your court, Judge, or for, appointment for you, Judge. And I'm trying to pull up the email, Your Honor, so I could send you.
Well, if the judge granted you relief, what did he do about the show cause?
The show cause, Judge, there was no order. I believe he gave a continuance for Mr. Spencer's client to appear at that time.
Okay, so.
And I'm sending you the email, Judge, right now. Actually, I'm trying to confirm which email I had sent before. Looks like. Omar Garza. Let me see if I sent it to you directly, Judge.
I received stuff from you, but I received a blank order on the TRO. It was like your proposed order. And I don't have it in my file, but for some reason, I had the impression that the judge had signed an order.
He did, Judge. He did sign the order. I'm trying to get that to you. I thought I had sent it to you. If not, it's possible we had sent you the unsigned order, but I'm sending you the signed copy right now, Your Honor.
Okay. Anything else you want to say, Mr. Spencer, before I'll let Mr. Spencer have Mr. De Leon about continuance of this matter?
Well, Judge,
I don't think your pleadings are in order either, Mr. De Leon. I mean, you don't have a will that you're offering. So
Well, Judge, they never produced it. We filed a petition to produce will. In our petition, we allege that we don't have the will, Judge, because they had never turned it over.
I'm sorry, I understood they had given you a copy of an unsigned will.
Yes, Your Honor, afterward, they had emailed us a copy after that, but we had been led to believe that it was a signed, duly executed will. After receiving the unsigned copy, that's no longer our contention, Judge. We are not proponents of the will at this point because there, in our understanding, there is no will.
Okay. Okay, I'm got you, the parties confused. So it's Mr. Spencer that's gonna assert that is a valid will.
Correct, Your Honor.
Okay. So in your pleadings, we don't have a show cause hearing, and we don't have theft or conversion or anything else that you could seek redress of your asserted grievances.
Just a show cause, Judge.
Well, it's not pending.
It was filed before they had requested the statutory probate, Judge. We would assert it is pending because the matter was it was
I'm
filed.
sorry, it's okay, it's pending, but I would need to set it for a hearing. Is there, you agree?
You're honestly, Judge, I understood today to be the hearing for the show cause, since that's where we left off.
Your response on that, Mr. Spencer? Why wouldn't that be well, I did say all pending matters in my order, other than you not being ready. What argument do you have to say that that's not right for hearing?
Well, Judge, the issue, again, I mean, I don't have any witnesses to contest, to rebut what the evidence they want to proffer. But, and I'm a little, I can't say I'm blindsided because you did send me notice, Judge, but as far as any pending matters, there's, I mean, that is such a, there's so many things that are pending, Judge. I mean, we certainly have, as far as whatever live pleadings are what is be appropriate. I mean, the first petition, the first application, the court needs to determine whether or not that Mr. De Leon clients has standing. Do they have jurisdiction to make the contest, the allegation that they're making? Do they have a legal right to make a claim for what they're claiming?
Absolutely.
And so before we can address, whether or not there's a show cause and who has show cause, we ask for a probate court judge to determine whether or not Mr. De Leon's client has any standing. And that to me is the first issue before anything can go on.
And your issue is whether his client is a son, an heir?
Correct.
Are you gonna do some paternity stuff? Are you gonna do?
Judge, the court could, the witnesses can testify to themselves, but there is paternity, that there is no biological relationship between Mr. Trigo and who is the father of Miss Larissa, who is on the property of the decedent. And I believe he submitted affidavits. If not, we had testimony before in prior proceedings that that there's no biological heirship. There is no heirship. And so, Judge, if we're in the probate court and Mr. De Leon filed for probate, the probate proceedings, I mean, there has to be, I think, a judgment of heirship, or an order, a judgment to omit a will into probate, something. I do have an application here, and I don't know where it's not, I don't know if it's filed or not, but I have in my notes that we asked to probate a lost will. So that's basically what we're contending, is that we have a will, we have some evidence, and then the issues that we want to present, the evidence we want to present to the court, that there's evidence of a will, however, it's lost, and the elements to meet that.
Is that pleading something you're gonna file or something that you have already filed?
If I have a copy here, and I just don't know if I filed it already. If I haven't filed it,
Have you received a copy of that pleading?
Judge, the only pleadings from respondents that I see in this case are the general denial, Judge.
I can have that filed by right now, Judge, if we need to do that. Because I
Judge.
I just don't have it.
Well, I'm gonna, Mr. Spencer, I'm gonna grant your motion, your oral motion for continuance, but I want to I want you to do whatever you're gonna do within 10 days.
Yes, sir.
Mr. De Leon, whatever please you're gonna file, maybe renew your request for a show cause hearing, something that joins the issue.
Thank you, Judge.
Give some thought to get your lawsuits in order. Theft, conversion, questioning the deed, Mr. Spencer. I mean, there was nothing in the file that I could see was at issue. And if you question the standing because of you assert that Mr. Aaron Trigo is not a son of the decedent. Is that what you were asserting, Mr. De Leon, that Aaron Trigo is the son of Mr. Gonzalez?
Yes, Your Honor, and we have filed affidavits of heirship, and we have our witnesses ready to testify to that extent, Judge.
All right, well, that, if the paternity is going to be questioned, and Mr. Spencer, I guess, get your, I don't want to have another setting where the pleadings are not in order, Mr. Spencer.
Yes, sir.
And if you're questioning the standing based on that issue, DNA issue, whatever it is, you have to figure out how you're going to put that before the court. That's relevant to standing.
Yes, sir. Judge, I don't anticipate that Mr. De Leon will produce a birth certificate.
Well,
You know, that's kind of where we start, and there's no evidence of that.
you think that answers the issue?
I think that that the birth certificate will indicate who the father is.
You said there is no, that his own birth certificate. Well, that's real strong evidence, but I don't think it's dispositive. If he thinks he was the blood son of the decedent, then you're going to have to go to DNA stuff.
Yes, sir.
There's certain presumptions with this, but that just doesn't happen from thin air. You have to have your pleas, and you have to, if you think that the birth certificate, contravailing birth certificate is dispositive on a motion for summary judgment, then let's look at it. But right now, I don't have a response from you on your pleadings, Mr. Spencer. All I had was an application to admit will, which Mr. De Leon, you're telling me you're withdrawing.
In my pleadings, Judge, I believe we stated in the event that a will is not a valid will is not produced, then we should name the heirs, Judge. It's like an alternative in our amended pleadings that were on file back in July of last year.
Yeah, I saw that. So I don't know. Okay, so somebody has to do an application to determine heirship. If that's, you have to.
Judge, we were hoping we could get.
You have to assert your heirship as a sworn pleading. I mean, you can't just list them on your application to admit will. You have to comply with the state's code about what are your assertions of paternity. So.
Understood, Judge. I understood it to be a twofold process. First, we determine if this blank will does in fact pass muster, and in the event it does not, then we have the sworn affidavits on file, affidavits of heirship on file, Judge, which we can fully prove up if we were allowed to today, Judge.
Okay, affidavit is not going to be sufficient. Just like birth certificates are not, in my opinion. If y'all, you do not have a valid application to determine heirship based on the pleading that you filed.
No, Your Honor. We have an application to probate will, which asks, which is based off a lost will or will not produced by respondents, rather. That in the alternative, if this will is not produced or is not determined valid, then we would ask for the heirs to be named, Judge.
Okay, that alternative pleading is not sufficient to render a judgment. Declaring heirship. And it requires that you swear, the four people and your applicant has to swear that those are the heirs. So,
Understood, Your Honor. So from my understanding, Judge, this court will accept amended pleadings in this cause number from us?
yes, both of them. Yeah.
Thank you. Okay.
That was the whole starting point for me is, okay, what are the live pleadings? What are the issues? To make sure we're gonna have to have a jury issue that is triable before a retired statutory probate judge. Because if there was no will, I didn't, absence a contest about heirship, then that preserves that issue. But you've got a lot of other stuff that it's not, I don't have pleadings to know where to go with this thing. So I think both sides have to work on their pleadings.
Understood, Judge. And you said you wanted these within 10 days?
Yes. I want both sides to make their best effort to join all active pleadings, seeking all affirmative relief so I can figure out how we're going to proceed with the case.
Understood. Judge,
And under show cause, I may set it individually. If you know, I guess you might send me a proposed order. What would result from the, I guess it would just be contempt of court for refusing to return the items. Is that kind of where that would go?
that's what we're getting at, Judge.
It's not gonna get you a judgment. It's not gonna get into any, I don't know, did you ask for a turnover or what? I mean, I guess that's post-judgment, so. Okay.
Judge, we asked for a fine, jail sanction, and attorney's fees.
A fine, jail, oh no, contempt.
Correct, Your Honor. Correct.
All
And Judge, I had spoken to my client about this, you know, and if the matter of the heirship versus the will, you know, is going to be what's stopping us from going forward, you know, I think we could happily, if the court would consider moving on today, we could move forward. We might even concede to the will, but we have the issues of the property. You know, that's really what we're trying to get at, Judge, because of the really, it's an extreme amount of time that has elapsed since we started this case, and there's been births and all kinds of things with the property at stake here.
Well, I don't know about you giving up on the will. I understood Mr. Spencer to say that the will leaves it to Yvonne Gonzalez and Gilbert Gonzalez Jr.
I understand, Judge. However, in our temporary orders that were the injunction, there was a specific finding that the deed was properly executed and recorded in Duval County, and that makes it outside of this the estate, Your Honor, property outside of the estate. So that's a non-issue.
Well, I guess we'll see what. Mr. Spencer, you need to figure out what you're going to assert and where you're going to file it on the land.
Absolutely, Judge. The court has given us 10 days and we will take advantage of those 10 days. Thank you, Your Honor. Judge, the 10 days.
And if he files it in, excuse me, Mr. Bennett, he files in probate court and you don't think this word belongs, Mr. Leon, then you file your responsive pleading. You know how to do that. You did your motion, your plea to the jurisdiction in Alice, so, you know.
Understood.
Okay. All right. Anything
Judge,
else?
the 10th date, just to be clear, Judge, 10 days is October 3rd, which is a Sunday. So October 4th is the deadline?
That's fine. Monday, October 4th at 5 p.m.
Yes, sir.
All right, if you'll send me a proposed order granting your own motion for continuance, Mr. Spencer, including that deadline for both sides, I'll sign it and give it back to you. This, I'm curious, Ms. Pais,
Yes, I'm coming.
okay.
Go ahead. I'm here.
That language about sending copies to the all council of record was the last sentence in 3-paragraph letter, so you all may not have seen it. Can you tell me whether they sent the notice to all council of record?
No, sir, I didn't find anything in here in the actual file, and there's nothing written also in the book. But I don't know if at that time they probably thought maybe with what you sent was enough to them, since you sent them an email, correct?
Yeah.
Uh-huh.
Well, I covered it both ways because I really didn't want the parties to have to go through a hearing with
Yes, sir.
exactly what happened. So that's fine. Okay, then I'll wait to get your pleadings from both sides and I'll respond to them accordingly. If there's nothing else, we'll be in recess. So,
Okay.
Mr. Spencer.
That's all for me, Judge. I just was trying to get somewhere in this case. I feel like our pleadings are sufficient under the estates code as far as going forward in the event that a will is not deemed valid. We would just ask to go forward again, Judge.
Okay. Well, I've already ruled.
Thank
Get
you,
your
Judge.
pleadings in order, both sides. We'll be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Y'all
May I
have
be
a-
excused?
Yes, y'all have a nice day.